look to the states to defend their prerogatives by adopting the simple expedient of not yielding. The states are separate and independent sovereigns, and sometimes they have to act like them. In California v. U.S., we can understand that this principle is true for the states, must also be true for the county and the municipality. With a multitude of examples, there ought to be no fear in implementing this long-standing principle of refusing to comply with unconstitutional acts of government. If the Supreme Court follows their own recommendations and precedent, there is no credible threat for successful litigation against a county that refuses to enforce any law or ordinance contrary to the constitutions. Finally, Mr. Rainwater also references the Amendment 14 as grounds for the county to not consider the ordinance. However, legal precedent agrees that this ordinance does not violate Amendment 14. Now, Amendment 14 refers to local or special acts that would be unique or special laws for that county. As Mr. Rainwater acknowledges, there is nothing unique or special in the proposed ordinance, but everything that is already required by every state, county, and municipal officer. The purpose of the ordinance is to specifically require the county to adhere to the Constitution of the United States and the Constitution of the State of Arkansas as demanded by their oath. Now, in reference to Amendment 14, the Supreme Court of Arkansas, I'm finishing up, sir. In reference to Amendment 14, the Supreme Court of Arkansas, in explaining the proper application of Amendment 14 in Layman Mayor v. Harrell, they quote State ex rel Borough v. Jolly. In determining whether a law is public, general, special, or local, the courts will look to its substance and practical operation rather than to its title, form, or phraseology, because otherwise prohibitions of the fundamental law against special legislation would be nugatory. A substantive and practical operational view of the proposed Bill of Rights ordinance indicates it is not a special law and would be authorized under both county's delegated authority and the right of the people as a power inherent in the people. The people are simply asking the county to consider this ordinance to secure their rights. Recent events give people justifiable concern regarding those elected under the trust to secure the rights of the people. We may not prevent an elected oath taker from wandering away from their duty, but we can reduce that temptation for the person in office to lose sight of their promise with a constant, visible reminder of that vow. History proves it is more than appropriate for the people to call for those elected with the trust of securing their rights to be reminded of that vow and have the appropriate political recourse to answer when that vow is broken. To say that people do not have that authority or that some law prevents that authority is to admit that the representatives of the people are superior to the people themselves. And then you will see men acting by virtue of powers do not only what their powers do not authorize, but also what they forbid. Thank you. Yes, sir.
And then I guess we can, subject to the body, we didn't have any questions and answers. That was about 17 minutes. I'm just saying that maybe, the Supreme Court gives you about 20 minutes. Maybe.
I came up with 3 minutes extra then. Thank you, sir.
Will we have time for questions at the end of Mr. Rainwater?
Well, okay, do you want to ask questions now, or do you want to ask her and ask questions to Rainwater after he does, or how you want to do it?
Doesn't matter as long as we have opportunity to ask questions.
So I guess we can get your mic and then questions about it.
Thank you very much. I want you to know that I have never said there's no need. Most of y'all know me and represented counties for 30 years.
Your organization
I've
has said
also
that.
been a deputy prosecuting attorney, and I've also written books, things like that. So I'm just saying, in the trenches, I've been representing counties for a long time. All those cases are constitutional cases. And one thing I know is that nobody really cares about a large opinion because larger advocates. And it's not really our job to come in and give personal opinions. It's our job to bring it forward. And when we stand before a judge, the judge wants to know if we have any legal authority. I have compiled articles, and I've got one here from each of you. I don't have time to read it, but I just want you to know that my job fundamentally is not to tell you how to run Sebastian County. I learned a long time ago. It's foolish for me to go to a county and tell that county how they should run their county. That's not my job.
It's what you're
It's
doing.
not my job here tonight. I will say what I did do is I prepared a substitute ordinance. And I prepared the substitute ordinance attempting to speak in your voice as a proponent for exactly what you want to do. The issue here is not what you want to do. The issue is the pathway that you choose for doing it. And this pathway issue comes down to the language in the various ordinances. So we have a proposed ordinance from whomever that the county is considering. And in response to that, in preparation for tonight, I drafted an alternative to that. I want to read you just some operative words out of my alternative for you. And this is the crux of the matter right here. It is declared to be the official policy of Sebastian County that the United States Constitution's Second Amendment right and the Arkansas Constitution's Article 2, Section 5 right to keep and bear arms will be honored by the officials and employees of Sebastian County as a constitutionally protected liberty right, and that any act of any legislature that abrogates the Second Amendment or Article 2, Section 5 of the Arkansas Constitution will be treated as void and unenforceable in Sebastian County. Now that is the crux of the ordinance you want to pass. What I'm trying to do is put it in wording that doesn't violate your oath. And you say, how can you violate your oath by saying that we're going to follow the Constitution and not do anything unconstitutional? Well, the answer to that is, that oath says you have to honor and obey both the United States Constitution and the Constitution of the State of Arkansas. The fundamental problem with the ordinance is it violates the Constitution of Arkansas because you have a local government doing what the state should be doing. There's nothing wrong with the county saying, yes, we will obey the Constitution. Yes, we will consider any act that violates the Constitution to be null and void. That's the principle of nullification. Generally, the principle of nullification is at a state level. Why? Because states are the creators of the federal government, and under the 10th Amendment, all powers not delegated to the United States are reserved to the states. So if the states think that the federal government is violating their own Constitution, which says they can only exercise delegated powers, then obviously the state can stand up and say, no, what you're doing, Congress, what you're doing, federal officer, whoever the federal actor is, violates your own Constitution, which we, the states, put into place. Now, this Constitution has been around since 1789. No right since 1791. And there's been a lot of years gone by in that time period, and we've been through a civil war, and the Civil War produced Amendment 14. I don't know which Amendment 14 you're talking about, Ms. Hall, because...
The Amendment 14 that you refer to in your document.
Read what I said.
That is in the Arkansas Constitution.
Okay, the Arkansas Constitution.
Yes, Arkansas
Okay.
Constitution.
After the Civil War, the resolution of the Civil War, the legal resolution was the ratification of 13, 14, and 15 amendments, okay? That federalized United States Constitution made that applicable to the states, to state actors. Now, back to where we were, what's my job? Keeps you out of the ditches. What are the ditches? The illegal ditch and the unconstitutional things. Okay? How you choose to run your county is your business. I'm here because I'm outside general counsel in the Association of Arkansas County Risk Management Fund. That's been in place since 1987. And that's what protects you. That's what provides the defense for you. Okay? And I've participated in over 6,000 lawsuits dealing with the United States Constitution. So you come back to the ordinance. Are unconstitutional laws void? Yes. Anything wrong with that? No. So what is wrong with the proposed ordinance that's before you? I'll show you. I want to make it perfectly clear. I never said there's no need for this ordinance. I never said that. Now, I may have said there is no need for the county to say what the Constitution already said. Okay? But if y'all want to pass an ordinance, pass an ordinance. You know, Scott County taught me this lesson. I went to Scott County one time, and I was trying to convince them what I thought they ought to do. They basically told me that I need to go back to Little. And on the way back, it did me like a ton of bricks. If I'm going to tell Scott County how to run their county, if you don't run your county, I need to move your county, I need to run for office, I need to settle this court, run for county judge, then I can make those decisions. Because I have a rightful place to do that. That's not my job. My job is to raise the stop sign or the danger sign when I say that you're about to step into the ditch. So let's look at your ordinance. Your ordinance says, find the section here. It's on your packet, the Court Court packet on page 32. It says the right of the people is further protected from infringement by state and local governments under the 9th, 10th, and 14th Amendments. Okay? That's true. Next statement. Sebastian County has a right to be free from the commanding hands of the state and federal government. That's flat out not true. That is not true. You're about to pass an ordinance that says Sebastian County is sovereign. And the reason you're saying you're sovereign is you are having a right to be free from the commanding hand of both the state government and the federal government. Does anybody in this room believe that you have a right to be free from the commanding hand of the state government, which created this county?
If they do something unconstitutional, yes. If they re-impose slavery or.
And has a right to refuse to cooperate with state and federal governments in response to unconstitutional state and federal measures. Understand that. Here's where the problem comes. Go down to section 3. It says notwithstanding any law, etc. No agent or official while acting in their capacity shall knowingly and willingly participate in any way in the enforcement of any unlawful or unconstitutional act. That's fine. The next 3 words are the problem. As defined herein. When the county sets itself up to say, I now get to pick and choose the definition, what they're doing is they're speaking as a sovereign, and you're setting your interpretation up as superior to the interpretation given by the state. That's unconstitutional. Section 4, unlawful act. Unlawful acts that consist of any federal, state, or local act, law, order, or regulation, which restricts individuals' constitutional rights, period. That's not a true statement. The reason we have a 9th Amendment and we have a 10th Amendment is because all of the rights belong to the people. All of the powers belong to the state.
And to the people.
Let's read the 10th Amendment.
Yeah.
What does the 10th Amendment say?
Please do that.
I'll read it.
The whole 10th Amendment.
10th Amendment says all powers are reserved to the states or to the people, right? Right? So how do the people exercise exercise their power.
Here are the states.
They exercise their power in a Republican democracy through their elected representatives. The state
Constitutional.
of Arkansas is the state. We are a political subdivision of the state, and as such, we cannot make an absolute rule that says any federal, state, or local act which restricts an individual's rights is unlawful. You're setting the county up as the superior sovereign. That's unconstitutional. You not only do that, you make it a crime. And here's the problem. You're substituting a new process for due process. Due process is the process of balancing rights against powers. And we have to have due process. Individual liberty rights, they have to be measured against the responsibility of the state delegated to the counties to do what? Maintain order, ensure security, and keep the peace. This ordinance takes that away. It says, no, individual rights are absolute. That's unconstitutional. That's illegal. Now, let me read you what the Constitution itself says, and I put it in the proposed ordinance.
That you didn't share with anybody else.
It says, give me a second. Article 2, Section 12, no power of suspending or setting aside the laws of the state.
Thank you.
Shall ever be exercised except for the general assembly.
So this is the first copy
Okay?
of this ordinance here. So this copy was not available. To the people. See, the problem is this is the same organization that blocked these ordinances weeks and months ago. And now they can't block them, they're trying to sabotage it. We refer to it as a poison pill. That's really what this is. Oh, I gotta take a picture of this.
I'm looking for the statute. Let's see, find it right now. Where it is. Arkansas Code Annotated 1416
Sure.
A local unit of government shall not act any ordinance or regulations pertaining to or regulate in any manner the ownership, transfer, transportation, carrying, or possession of firearms except as otherwise provided by state or federal law. Did you get that? The county has been ordered by the state not to be in the firearm business. Your ordinance, your proposed ordinance, violates that law and therefore violates the Constitution. As a consequence, as written, this proposed ordinance is unconstitutional and it's illegal. I'm just simply saying, where both of office says, I've got to obey the federal Constitution, I got to obey the state Constitution. In the act of trying to dissolve our rights under the U.S. Constitution, we cannot violate the Arkansas Constitution. And the Arkansas Constitution says that we are not to be in the business of enacting ordinances or regulations pertaining to or regulating in any other manner ownership, transfer, transportation, carrying, or possession of firearms, except as otherwise provided by state or federal law. And there is no other provision. Therefore, the way this is written, you've gone too far because you're stepping over into telling the state, I don't care what you do, I'm assuming that no, what we can't do, we're going to do it anyway. Now, that's a violation of your oath. That is the point that I made throughout this, that to violate Arkansas law, trying to uphold the U.S. Constitution, specifically the Second Amendment, is unconstitutional in Arkansas, and it violates your oath of office. If you violate your oath of office, then there are consequences to that. I'm simply saying, why not consider a substitute ordinance that does not have these defects in it? I have drafted a substitute ordinance, and here's what it says. It says, whereas it is our sworn duty as elected representatives of the people, under Amendment 10 and under the Arkansas Constitution, Article 2, Section 1, to do our part to guard against any unconstitutional denial, disparagement, or encroachment of any enumerated or unenumerated rights of the U.S. Constitution. Amendment 9, or Arkansas Constitution, Article 2, Section 29, those promises are to be retained by the people, accepted from the general powers of the government, and forever remain inviolate. Number 1, Sebastian County is declared a Second Amendment county as an expression of Sebastian County's desire to join the present nationwide effort to affirmatively state county government support for the U.S. Constitution, Bill of Rights, Second Amendment, and the statewide support to affirmatively state county government support for the Arkansas Constitution, Article 2, Declaration of Rights, Section 5, that's the right to bear arms, keep and bear arms. As written and historically interpreted and applied to Sebastian County, hereby officially designated a Second Amendment county. Number 2, Sebastian County officials and employees shall uphold each and every provision of the Bill of Rights in the U.S. Constitution and the Declaration of Rights in the Arkansas Constitution, and specifically, Sebastian County officials and employees shall uphold the right of citizens of this county to keep and bear arms as guaranteed by the U.S. Constitution, Amendment 2, and Arkansas Constitution, Article 2, Section 5. Then we get to number 3, unconstitutional laws are void. It is declared to be the official policy of Sebastian County, the U.S. Constitution, Second Amendment right, Article 2, Section 5, to keep and bear arms, will be honored by the official employees of Sebastian County as constitutionally protected individual liberty right, and any act, any legislature that abrogates Amendment 2 to the U.S. Constitution, Article 2, Section 5 of the Arkansas Constitution, be treated as void and unenforceable in Sebastian County. Number 4, since it is clear from both the U.S. Constitution, Amendment 9, and Arkansas Constitution, Article 2, Section 29, that individual liberty rights, including the right to keep and bear arms, belong to the people and are to be forever retained by the people, Sebastian County officials and employees shall neither interpret nor construe any legislation in a manner that would deny or disparage the Bill of Rights or the Declaration of Rights, and shall guard against any encroachments on the U.S. Bill of Rights and the Arkansas Declaration of Rights, including the right to keep and bear arms. Finally, number 5, Sebastian County official employees shall support the Constitution, Amendment 9, and Arkansas Constitution, Article 2, Section 29, concepts that individual liberty rights enumerated in the U.S. Bill of Rights and the Arkansas Declaration of Rights, including the right to keep and bear arms, are accepted out of the general powers of the government and shall forever remain inviolate. Number 6, and this is key on the part that is effective in the proposed ordinance, due process. Sebastian County officials and employees shall use the state's political divisions of police powers reserved for the states by the 10th Amendment, the U.S. Constitution, as is necessary and constitutionally justified in order to maintain order, ensure security, and keep the peace in the land. All to be done in a manner that both recognizes the people's individual rights, which shall forever remain inviolate, and complies with the constitutional requirements of due process, including, and I've cited Fourth Amendment, I cited Article 2, Section 15, which is the Arkansas counterpart to the Fourth Amendment. I cited 14th Amendment, Section 1, and Arkansas Declaration of Rights, Article 2, Section 8, which says, nor shall any state deprive any person of life, liberty, or property without due process of law. And finally, I cited Amendment 14, U.S. Section 1, and Arkansas Constitution, Article 2, Sections 2, 3, and 18, which says no state shall deny to any person within its jurisdiction the equal protection of law. And then finally, redress of wrongs. In addition to asserting his or her due process rights, any person who believes his or her right to keep and bear arms, as enumerated by the Second Amendment, Article 2, Section 5 of the Arkansas Constitution, If they allege it's been violated, they may seek redress through the civil process. For in Arkansas, and here's another constitutional right under the Declaration of Rights, which there's 29 of them, in Article 2 of the Arkansas Constitution, it says, quote, every person is entitled to a certain remedy in the laws for all injuries or wrongs he may receive in his person, property, or character. He ought to obtain justice freely and without purchase, completely and without denial, promptly and without delay, conformably to the law. I submit to you that this statement of what you want to do, which is perfectly right, and that is to affirm the Second Amendment and to remind the officials we have a duty to obey both the U.S. Constitution and the state Constitution. This wording is wording that does not violate the Arkansas Constitution, which says you cannot abrogate state law, and furthermore says, the General Assembly says, counties and local governments, we want you to stay out of the business of regulating the market. That's where we find it. If we ignore that, I submit to you, and I'm here to tell you that you've been told that those provisions exist in the Arkansas Constitution and in Arkansas law. If you ignore those and go forward and pass this first ordinance, I think it's a violation of the code to obey the Constitution of the state of Arkansas. That's my message. That's my message. You know, I don't conceal carry like I love the Second Amendment. I love the Constitution. I want people to pay attention to Article 2 of the Arkansas Constitution. There's 29 things in it. We have an amazing constitutional system. Amazing. We've been through 230 years or so trying to figure out what all that means. We're still trying to figure out what it all means. But that document, you know, it was the miracle of Philadelphia. That document, I believe, it was just a divine moment in history where a whole lot of things came together. I put it right up there with Scripture. Almost. Not quite. I can't go that far. Almost. It's not God's word, okay? But I'm saying, flat out, Second Amendment is alive, Second Amendment is real. The origin of this is our natural rights, our God-given rights, our inalienable rights. You know why they're inalienable? Because God gave them to us, and the government can't take them away from us. That's why. And that's what this Constitution stands for. I'm saying use the right language to do the right thing for the right reason. What's the right reason? Nullification is really what Ms. Hall was pushing. She wants the states to stand up and exercise their rights under the 10th Amendment on behalf of the people who have their powers under the 10th Amendment. On behalf of all the people whose rights are given to them in violence under the 9th Amendment, to stand up and say, wait just a minute. You're going too far. The U.S. Constitution provides delegated powers to the federal government. It reserves only undelegated powers to the state government. It says the people, their rights are given them by God. Fundamentally, the reason we have a Second Amendment is because we have a natural right to defend ourselves. The Arkansas Criminal Code says that we are justified by doing what? Using force to defend ourselves or others in a situation where it's a choice of evil or in an execution of duty. And I'm telling you, these officers right here, don't let them down. Don't take their power away from them. Give them the opportunity to maintain order, ensure security, and keep peace in this county. And I implore you, don't violate your oath. That is my message. It is not my personal opinion. I've cited the law for that, and I'm done with it.
I'm a police officer in the city of Hot Springs, and I was glad to know that every person who was responsibly armed would have my back.
Then you probably know my name. What's my name? You think I haven't been through it like you have? I represent these officers for 30 years. I care about officers probably more than anybody in this room. Simply because they have a duty and it's a hard job to do. And I want you to know flat out, I know exactly where you are. I've been an officer practically my whole living career.
Can I ask Mr. Reinhardt a question?
This has been around since May of last year, and it's ain't been a problem.
I do have a point of order when that's appropriate.
Why don't you come forward and if you have some more comments, in the interest of fairness, if you have 5 more minutes if you want to talk.
All right, thank you, I appreciate that. First, my point of order is that Mr. Rainwater, in his closing, said that Chris Ann Hall wants you to nullify it. I would.
You just said that. You just did, man.
And so.
Oh, here's a pillar
I
flag
just
in.
wanted you to recall what I presented to you.
It's
Never
the
once
third time you said I didn't
gave
say
you
that.
What I think. Everything that I gave you was based on the Supreme Court, based on what the founders themselves said. So that would be my point of order. I took a bunch of notes based on Mr. Rainwater's presentation. It was a little convoluted, so it was difficult for me. Do you have this document right here? May I approach?
Sure. They have had numerous documents. I'm not sure, probably had that.
This is the one that I was referring to, and in the third paragraph, second sentence, Mr. Rainwater writes, "There is simply no need for any county to declare itself a sovereign jurisdiction and to step forward to create some sort of sanctuary for the protection of individual rights."
That's what he said.
So I just want you to realize that I was quoting from him. I'm not trying to be misrepresenting or disingenuous in any kind of way. I think what's important to realize here is that this ordinance is more than just about the right to keep and bear arms. I teach the Constitution, and if you'll allow me, I will tell you, and I'm going to give you my opinion. When I do that, I always tell you I'm going to give you my opinion. I have a little pet peeve when people call things constitutional rights. Your rights don't come from the Constitution. And so we have to understand that by the county saying we will not enforce a law made by the state that is unconstitutional. Sebastian is free from the commanding hand regarding unconstitutional laws and acts. Not a blanket free from the commanding hand, but free from the commanding hand of unconstitutional acts. And in doing that, may I mention to you, you are not declaring yourself superior to the state by doing that. What you're doing is declaring that the Constitution of Arkansas is superior to the General Assembly.
Yes.
You are not breaking the law when you refuse to enforce an unconstitutional law. What you're doing is enforcing the supreme law of the land when those who have written that law are violating that. And that is the crux of your oath. It's like I said, your oath does not say you will support and defend the Constitution of the United States, the Constitution of the state of Arkansas, and the laws and statutes. That's not there. Because we know and understand that laws and statutes are written by men, and men in the gender neutral sense, just so we don't understand here, but people are not infallible. And people can be emotional and pass laws for the wrong reasons. That's why we retain that authority. So you're not declaring that you're superior to the state. You're declaring your oath requires you to make the state inferior to the Constitution itself. You are not taking your rights. I don't understand why there would be any question in this body on the inherent, inalienable nature of the people's rights. To say that your rights are limited is to deny Article 2, Section 2 of the Arkansas Constitution. All men are created equally free and independent and have certain inherent and inalienable. That means they come to you by the nature of the situation, and inalienable means they cannot be taken away. I can't think of any more complete definition of a right being complete than that. To say that they're limited is to say they're not inalienable. They're not inherent. Now, I understand that there were several arguments going on. I'm not going to go through my whole presentation again. You heard what it says. And I think that what I can do, Mr. Chairman, is provide you with my presentation in writing for the committee members.
Oh, okay, I think you had about 5 minutes, and that's about how many more minutes he had, so I think we both spoke about the same number of minutes. It may be appropriate now to entertain questions, each one of them from the court. So that would be either to Ms. Hall or Ms. Greenwood, or to both of them.
Well, first off, thank both of you for being here tonight. We appreciate that. This may be for you too, mainly for Mr. Raymore. Does the county have the authority to suspend or set aside a state law?
No.
Okay. So if the state makes an unconstitutional law, we have no authority to set it aside.
Not as a court. Go back to square one. We have executive, legislative, and judicial. And your powers are for local matters. And if the state of Arkansas has already legislated on a matter, then that matter is now state law. And the county cannot violate the Constitution, which is my whole point about violating the code. The county cannot defy that state law. Now, you say, well, what are we going to do about that? It's not the job of the legislative branch to go out and actually implement the law. That's the job of the executive branch. This sheriff over here has a separate oath. Constitutional officer. You're a constitutional officer, but you're a constitutional legislative officer. He's a constitutional executive officer. He certainly has the duty, pursuant to his own oath, to follow both constitutions. And if he determines that a law that's passed by either sovereign is unconstitutional because it violates the Constitution itself, then he, pursuant to his oath, would not enforce that law. And you say, well, how can that be? Well, let's take Rosa Parks for example. Now, what if the sheriff had gotten on the bus and came over and said, hey, I agree with you, Ms. Parks. I'm going to protect you. I'm going to ride with you. That would be an example of how the sheriff could choose to obey the Constitution, a higher law. Now, somebody can come in and say, well, Mr. Sheriff, I agree with you. That's what the judicial branch for, is to solve those problems. The reason we have separation of powers, and we want all of them to use all the power that they have, is what happens is they check and balance each other, but there's no mechanism for basically holding them accountable except each other. So you end up going to the other branch. You need to go back to the General Assembly, make the law more clear, or you go to the court and say, this sheriff failed to follow the law, therefore he's guilty of misdeeds, malfeasance, or nonfeasance. Have it set up the controversy, then the court would rule on that, and in one case of controversy at a time, we would figure out whether he's right or whether all this is to be done orderly. And there's a hierarchy of power out here. The counties are political subdivisions of the state. The cities are political creatures of the state. Cities are municipal corporations. But counties are both body politic and corporate. They operate in both capacities. And in their body politic capacity, they operate for the convenience of the state to administer the state duties. This is why the county can be sued for state actors. Okay? It's being for state actors, and the 14th Amendment says, nor shall any state deprive any person of liability or property without any process of law.
Could the state be sued?
The state cannot be sued in its own court, no, but the state actor can be sued.
Okay, so where is a citizen's, where does he go when his constitutional right has been violated by state law, that the county does not protect him from?
He can either, multiple choice, okay? Well, under the, what's called 1492, section 1983, the Title 42 United States Code, which was originally called Ku Klux Klan Act. The very purpose of that is to take a state actor who's abusing or misusing their power, you can say violating their oath, and make them accountable. And the statute says for money damages or injunctive relief, there's a fee shifting statute. These are the cases I've been involved in my whole career. There's also an Arkansas Civil Rights Act, but you can sue a state actor in federal court for violating the provisions of the U.S. Constitution, and you can have a dependent state court matter go up with it, and also have a lawsuit for violating the state constitution. Now, you can't sue the state in its own court, just set up a state claims commission. You cannot take the state to federal court, that's the 11th Amendment. But you can still sue for injunctive relief to say this act of the state is unconstitutional, and you can also sue the state actor for personal liability for violating the Constitution. There is a civil remedy, and that's passed pursuant to Section 5 of the 14th Amendment of the United States Constitution.
Is that what the problem is with the other ordinances? There is a penalty in there for someone
The problem
violating.
with that ordinance is, number one, it declares the county to be sovereign. We have the right to be free from the commanding hand of state and federal government. That's what it says.
That's only half the statement, though. You have to take the whole statement in context to be legally accurate, don't you?
No. Listen to this. You tell me this is true or not.
He's been talking for 5 minutes.
Free from the commanding hand of the state and federal government. That's not true. It says, and has the right to refuse to cooperate with state and federal government officials. That's a separate. So that's really 2 clauses. And you can say Sebastian County has the right to be free from the commanding hand. And you also say Sebastian County has the right to refuse to cooperate with state and federal government officials in response to unconstitutional state and federal government measures.
So let me ask you, so what I've witnessed over the last 90 days across the country is governors making rules. Some people can't go to church. Things that I thought I would never see. What is the remedy of the people?
Those are executive orders.
Yes.
Okay?
So what is the remedy for?
Let me give you an example, a classic example of executive order. The Emancipation Proclamation was an executive order. Okay?
But that's a state.
The 3 powers,
Doesn't affect
executive, legislative, and judicial, they're separate powers, and they all have power. And they use that power as executive order. The remedy is to go to court and say, you, sir, have violated the Constitution, and have the court order them to stand down from it. They can't do it, they've exceeded their powers.
You say with sovereign immunity, though, we can still, an individual can still hold the state accountable.
The state itself,
I mean, tell me how, if someone that's been, had their constitutional rights can be violated, with the state having sovereign immunity, what can they do?
I've defended 6,000 cases where they allege that there were lawsuits against the government. They're all against the county government. Those are all county lawsuits. The popular thing is to file a case in federal court and say we violated the U.S. Constitution.
Against the county?
Against the county.
What about the state?
Against the state. Again, you can't sue the state and federal court because it's a minimum,
Yes, you said that.
11 minutes.
Okay, so if the state has
State,
done,
you go to state claims commission, but you can't get it injunctive.
okay, so if the state does unconstitutional law, the county does not protect against that, you say we don't have the authority to do that, we have no need to do that, you're saying. But yet the
You don't have
state
power.
don't have the power to do that, but the state has sovereign immunity.
Yes.
Yes.
So where does that leave me?
Sovereign immunity doesn't mean that you can't go to court. It means that you can get a money damage judgment against the state. You get a money damage judgment against the state over the state claims commission. Okay?
State claims.
But we're not really talking about money here. We're talking about power.
Right.
If they exceed their power, that's the reason you go to the judicial branch, and have the judicial branch say, you've exceeded the power given to you by the Constitution.
and you get broke.
I wanted to ask Ms. Hall one question about, could you run that over real quick? You say the county is a sovereign entity.
Yes.
One more time, let's go. Because what you're saying is not.
It's absolutely not sovereign.
Okay.
Well, it has to be sovereign. If it's not sovereign, then it can't fulfill its duties under delegation of power.
Right.
If you are not sovereign, you cannot contract. If you are not sovereign, you cannot engage in the activities that are required of you under our code, under Arkansas code. Now, a body politic, by definition, is sovereign in its delegated authorities. And, excuse me, yes, delegated, and Article 14, Arkansas Code 14-14-501 says, not only are you sovereign in what's delegated, that you possess legislative powers not denied by Arkansas Constitution or by law. So, does the Arkansas Constitution deny you the authority to defend the people when the state passes unconstitutional laws?
I would like to think not, but you seem to say that it does.
Well, you would have to be able to quote the section in the Constitution that says that. And you asked about executive orders. Executive orders that are expected to be enforced as if they are law are one of the most severe violations of the Constitution that exist. It is the violation of separation of powers. Let me read this to you, because this is your Constitution. Article 4, Section 1, the powers of the government of the state of Arkansas shall be divided into 3 distinct departments, each of them to be confided to a separate body of magistrate, to wit, those which are legislative to one, those which are executive to the other, and those which are judicial. Article 4, Section 2. No person or collection of persons being one of those departments shall exercise any power belonging to either of the others, except in the instance hereinafter expressly directed or permitted. Hereinafter in the Constitution. Article 5, Section 1. The legislative power of the people of the state shall be vested in the General Assembly. Article 6, Section 1. The executive department of this state shall consist of a governor, lieutenant governor, secretary of state, treasurer of state, auditor of state, and attorney general. Your Constitution declares executive orders by the governor that are expected to be enforced as law under penalty of law, specifically violating your Constitution. And for the county to simply say, our oath means nothing. We can't support and defend the Constitution of the United States. We can't support and defend the Constitution of the state of Arkansas. We cannot protect the rights of the people. We must bow to the state. We must lay prostrate before the courts and beg for their mercy. Has anybody here ever had to deal or file a federal lawsuit? Because I have. I've been a plaintiff. Anybody know how long it takes? If your only recourse is to plead to the government to sue the government, then you are not a freeman.
Well, that seems to be what he's saying, right?
Yeah, and that's exactly what he's saying. So you either have to admit that you are not a freeman, or you have to realize that the Constitution of the state of Arkansas begs you to defend the rights of the people. That's the whole purpose. And if you cannot, if we accept what Mr. Rainwater says to be true, which by the way is contrary to the Supreme Court of the United States. So if you want to talk about lawsuits, you want to talk about authority, the Supreme Court of the United States has never held that a county cannot defend the people's rights by refusing to enforce an unconstitutional law. Never held that. And to the contrary, I've given you 3 cases now where they have said that the county is sovereign and independent. and that their laws are, and that they have the authority to not enforce laws. But if we admit that what Mr. Rainwater proposes, which is not in your Constitution, which is not in any Supreme Court opinion, then we must all admit that we do not live in a constitutional republic. That we live in a totalitarian oligarchy where the state can issue any law that they want, and the only check and balance is the state. I just can't wrap my brain under a logic that would allow us to concede to that. It is contradictory to every issuance of natural law. It is contradictory to every issuance of the Constitution. And again, I would simply say, legally speaking, if the county's not sovereign, guess what? All your contracts are null and void. Let me ask you a question. Can your 15-year-old make a legally binding contract? Why?
Too young.
Because he's not sovereign in the eyes of the law. If the county is not sovereign, every contract that you make is null and void. Every article that you issue is null and void. You have to be sovereign. And you have to be able to defend the rights of the people. Remember, the Declaration of Independence says that to secure that the governments are instituted among men, governments. Okay, there was no federal government on July 4th, 1776. They're talking about state and local governments. Governments are instituted among men to secure the rights of the people. If you cannot secure the rights, then why do you even exist? Because your oath does not contain an oath to financial responsibility. You may have that by law, but it is not your oath. Your oath does not contain a responsibility to kneel before an assembly and accept whatever law they pass, regardless, because the minute you do, your Constitution is no longer supreme. You do no longer operate by the rule of law. You operate by the law of rulers.
Yep.
There's a lot of legal rhetoric in there that's just not.
Example.
You are a legislative body. You're not an executive officer, you're not in the executive branch. Most of what you just talked about pertains to the executive branch, not the legislative branch. Now, I just want to read to you Section 12, Article 2 of the Arkansas Constitution. This is in the individual liberty rights section, by the way. So this is not in there for the county, it's in there for us as individual citizens. This says, no power of suspending or setting aside the law or laws of the state shall ever be exercised except in the General Assembly. Now, if an executive branch officer, pursuant to their oath, determines that a law is unconstitutional, and they act upon that oath, that's their job. But for the legislature to come in and make statements, like are made in this ordinance, that Sebastian County, this legislative body, has a right to be free from the commanding hand of the state. That's just flat out violating Section 12 of Article 2 of the Constitution. The statute that we're dealing with, if I can find it, I just want you to think about that when you vote on this ordinance and you read these words. And the specific statute
County and nothing.
about firearms. The reason that was passed was to keep local governments from doing what? Passing laws to take away, to regulate firearms, to diminish the Second Amendment, either the Arkansas version or the federal version. And so the Arkansas General Assembly flat out said, I put my finger over here.
Here we go, yeah.
It's the one I read earlier. You're not being in business of regulating firearms, what it says. Here it is, 14/16/504. A local unit of government shall not enact any ordinance pertaining to or regulating any other manner the ownership, transfer, transportation, carrying, or possession of firearms except as otherwise provided by state or federal law. My point is, and she says, well, we're sovereign to the extent we've been delegated powers. I don't have a problem with that. One of the delegated powers is what? Engaging contracts. That's what Amendment 55 is all about in Arkansas. They completely reorganized county government and set it up where all the delegated powers, and they delegate just about everything you want to do. But there's some things that the General Assembly says, don't do this. And I'm just simply saying, if you choose to do what the General Assembly told you you're not supposed to do, then ask yourself, are you violating the oath you took to obey the Constitution of Arkansas? When the Constitution of Arkansas says you're not to suspend or set aside the law or laws of the state, and that's an individual liberty right. So the ironic thing is, in the act of trying to protect our constitutional rights, you want to violate our Constitution and you want to disobey a command from the General Assembly. I'm just saying that violates your oath. Period. It's a dilemma. I'm pointing out the dilemma. But my ordinance, I wrote it to try to express the high and exalted state of the Second Amendment and the Arkansas version. I put in there some really interesting language about the Arkansas militia. Y'all know that every able-bodied male citizen between the ages of 18 and 45 by Arkansas Constitution is a member of the Arkansas militia. You don't go sign up. The Constitution says you are a member of the Arkansas militia. You'll be called up by the governor at any time. Of course Arkansas contemplates an armed citizenry. Of course our founding fathers contemplated an armed citizenry. This ordinance I presented to you, it exalts all of those historical rights. But there's more to play here than that, or we wouldn't be having this discussion. I'm simply pointing out, and I'm asking you, not to violate your oath under the Arkansas Constitution in an effort to protect individual rights under the federal Constitution. It's a dilemma that you're faced with.
A dilemma that's never occurred before.
Can I ask,
It's been over a year.
both of you one question? And I think this is probably what initiated a lot of this.
Microphone.
It's not working, I'm sorry.
You can borrow a mic from someone else, I'm sure.
Anyway, I can talk now, a lot of people say I'm.
There you go. You got a gentleman giving you a mic.
Do
No.
you think that it's a possibility that this ordinance came about because of some actions in states? And I don't think Arkansas will do this, but I think the concern of the citizens is, across the country, we are seeing states passing laws as confiscating firearms from people own. Is this not a violation? And this is my question. Is this not a violation of the United States Constitution, like Arizona, for instance, collecting firearms,
Virginia as well.
outlawing firearms?
That would be a violation, not simply of your right to keep and bear arms, but that's also a violation of your right to due process and your right to secure your property, not just simply from unlawful searches and seizures, but you're talking about a seizure of property, which invokes the right to due process and the right to have just compensation. I can tell you from the people that I've talked to at the Arkansas Liberty Coalition, you know, I'm not sure where the hitch is in understanding the Bill of Rights ordinance, because it's not just about the right to keep and bear arms. It's not. And a substitute ordinance for this that only focuses on the right to keep and bear arms, which, and an ordinance that has no teeth at all, is not going to be a suitable replacement. Because what we're talking about here, yes, our founders, and yes, the founders of the state of Arkansas contemplated an armed militia, but they also contemplated a governor who does not make laws. They also contemplated a right of the people to be secure
secure in their property, that the government cannot take your property without due process and just compensation. And in order to shut down your private business because of an illness or a pandemic, without due process, without just compensation, is a violation of your Constitution. To shut down a church is a violation. I don't even have to tell you what kind of violations those are. So this ordinance is built to respond to what people have seen, maybe not simply here in Arkansas, but also all over the country. One of our founders, Richard Henry Lee, said, "We are not to only guard against what political power will do, we are also to guard against what political power may do." That's why our constitutions are a delegation of power, not a removal of power. Our governors and our states are not told, you have every power you want to exercise unless we tell you no. We have specifically enumerated their powers. It's not a conflict of interest in your oath to say that's unconstitutional and I will support my people and not enforcing that. I mean, you bring up the role, Mr. Raymond brought up the role of Rosa Parks. How much different would our civil rights movement be? Yes, if the sheriff stood up, but how much different would our civil rights movement be if the local government said, we're not going to be enforcing these laws? Then the sheriff wouldn't even have a What I'm telling you is not unheard of. It is not new, it's not novel, it's not radical. There are counties all over the United States that are doing this exact thing.
Half over a year.
Well, they've been doing it for a very long time, not just a year. And so the people just want to know that the purpose of government is to secure, they know that the purpose of government is to secure their rights. It is not a conflict in your oath to declare your constitution superior to the state. If let me just put it as plainly and simply as possible. If your assembly can write a law that is not authorized through the Constitution, or worse, conflicts with the Constitution, and you must sit back and be an agent of application, executive branch enforcement, but in a way you have enforcement power too, because you're the ones that are saying we're going to make this happen in this county. What you're actually saying now is the assembly is above the Constitution itself. That's the conundrum. That's the conflict. Either the Arkansas Constitution is the supreme law of your state or it's not. And if the assembly can write whatever law they want, and you're just left to do nothing about it, it's not a denial of power from the sheriff for you to do this. It's not a denial of power to your police officers to do this. My goodness. It is actually an assistance to them because you're not making them step out. Governments are built for checks and balances. That is true. But Thomas Jefferson said they're co-equal checks and balances. You're not excluded from checking and balance just because the executive holds a check and balance. You're not excluded from that in any way. You're an obligation as a legislative body to engage in checks and balances. But when government works, it works together so that the legislative body supports the executive branch and the executive branch supports the judicial branch, and that is only just in good government when it's working fluidly under the restraints and respect for the Constitution. Because what you're being told is that if the Assembly writes a law that you know is contrary to the Constitution, you have to go along with that and you can't do anything against it. What you're being told then is that you must then support the violation of your Constitution
instead of supporting the preservation of that element.
I don't know very much. You are very, very good. Both you are very, very good at what you do. You both gave very powerful arguments, and I think everybody here would like to thank you very much.
Thank you, sir, I appreciate that.
Jim, did you?
Thank you for everything.
Oh, Ms. Hall.
Yes, ma'am.
Do a little walking
Yes,
there.
both of you attorneys have said a lot tonight, and I really appreciate that. Just one short statement from you. Very clear, Mr. Rainwater believes that we would violate our oath of office if we voted for the Scott County version of this ordinance. And is it, from all that you said, I gather is your legal opinion, we would not be in violation of our oath of office. In fact, we might be in violation of it if we didn't pass it. Is
Absolutely.
that correct?
Absolutely, and I would offer you, I would submit to you that that's not simply my opinion. That is the opinion of the Supreme Court, that is the opinion of the founders of our constitutional republic. It is the opinion of Montesquieu, the political philosopher that influenced our founders. It is the opinion of John Locke, who is one of the foundational, premier minds on natural law. It is the opinion of political philosopher Alan Vernon, who also influenced our founders, both on state and federal levels in the creation of their constitution.
Thank you for answering that. Also, I'd like to say thank you to Mr. Rainwater and to you, Ms. Hall, and all of you who took the time to speak today. Mr. Dunn, I appreciate everybody contacting us. We're here representing our constituents, and I thank everybody very much.
I would just like to thank you for giving me the opportunity to come before you today. I can't tell you what an honor it is that you would be willing to allow someone like me to come and give you this information.
We ready to move on? Thank you both for a very detailed presentation, a lot of passion, appreciate that. With that, you have two ordinances for you to, what is the will of the body? You want to have the clerk read this ordinance?
That's the clerk to read the Bill of Rights ordinance, and then I will make a motion to approve that Bill of Rights ordinance after she has read it. This would be, clear up any confusion, this would be the Scott County ordinance.
The Scott County would be the Adam Pay, that would be on page third. So the ordinance is already on the agenda, go ahead and read the ordinance, and then we'll go from there as far as motions.
Emergency ordinance number 2020. Be it enacted by the Court of Attorney Sebastian, State of Arkansas, an ordinance entitled Bill of Rights, Sanctuary, Sebastian County. Section 1. The Court of Sebastian County hereby finds and declares. Section 2. In order to ensure the rights of the citizens of Sebastian County, which are protected by the United States Constitution and the Bill of Rights of that Constitution, which reserves the right of the citizens to decide on matters which concern their lives, liberty, and property in the ordinary course of affairs. Amendment 1. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceable to assemble and petition the government for a redress of grievances. Amendment 2. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Amendment 3. No soldier shall be allowed to be ordered in any house without the consent of
Yes,
the
honey, sorry, I was using the Zoom camera. Sit down for a little bit.
Amendment 4. The right of the people to secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated,
She's reading
and
what
no
I
warrant
believe is the
shall
original
issue but
ordinance,
upon probable
not the
cause
rainwater
by
poison
law
pill ordinance, if
or
I'm not
of
mistaken.
proclamation, and particularly describe the place to be searched, and persons or things to be seized. Amendment 5. No person shall be held to answer for a capital or infamous crime unless on a presentment or indictment or grand jury, except in cases arising in the land or a naval forces or in a military, whether in actual service in the line of war or public danger. Person is subject for the same offense to be twice put in jeopardy or life or limb. Nor shall be compelled in a criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Amendment 7. The suit at common law where the value in controversy shall exceed $20, the right to trial by jury shall be preserved, and non-facts trial by a jury shall be authorized to be examined in any court of the United States that according to the rules of common law. Amendment 8.
Portable battery.
Excessive bail shall not be required, nor excessive fine imposed, nor cruel and unusual
Yeah, she's a little
punishments.
softer spoken, I think.
Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Amendment 10. The powers not delegated to the United States by Constitution,
Yeah, she's reading
nor
the comments on
committed
this, which is.
by it to the states, are reserved to the states respectively, or to the people.
Or to the, that's the part that Mr. Rainwater left out.
The court report further finds that Section 1 of the 14th Amendment to the Constitution of the United States, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws, passed by Congress June 35, 1866, read by July 9, 1868. The right of the people is further protected from infringement by state, federal, and local governments under the 9th, 10th, and 14th Amendment of the Constitution of the United States. D. Sebastian County has the right to be free from commanding hand of the state and federal government, and has the right to refuse to cooperate with state and federal government officials in response to unconstitutional state and federal government measures, and to proclaim a Bill of Rights statutory for all Latin citizens in their citizenship. Therefore, through the enactment of this document, Sebastian County, Arkansas is hereby declared to be a Bill of Rights statutory. Section 2. notwithstanding any law or regulation, rule, or order to the contrary, no agent, department, employee, or official of Sebastian County, I believe it was a subdivision of the state of Arkansas, while acting in their official capacity shall knowingly and willingly participate in any way to the enforcement of any unlawful or unconstitutional act as defined therein regarding freedom of religion, freedom of speech, freedom of the people to peacefully to assemble, freedom of the press, freedom to issue the government for a reference of premises, the right of the people to keep and bear arms will not be infringed, and Amendment 127 of the Bill of Rights. Section 4. An unlawful act shall consist of any federal, state, or local act, law, order, rule, or regulation which restricts an individual's constitutional rights, and such unlawful act is invalid in Sebastian County and shall not be recognized by Sebastian County and shall be considered null and void and of no effect in Sebastian County, Arkansas, and this shall include but shall not be limited to the following. 1. Any tax, levy, fee, or stamp imposed on firearms, arms, accessories, or ammunition not common to all other goods and services on the purchase or ownership of those items. 2. Any registration for tracking of firearm accessories, or 3. Any registration or tracking of the owner firearms accessories, or ammunition. 4. Any act forbidding of the possession, manner, ownership, or use of transfer of any type of firearm accessory, or ammunition as citizens of the legal age. 5. Any act ordering the confiscation of all firearms, firearm accessories,